Hello, students. For those of you who have not watched the previous video, I'm Lawrence Likar. I'm a professor of Justice Law and Security at LaRoche College. This is an online video lecture on constitutional law dealing with the freedom of speech. And to begin, we're going to be looking at the First Amendment today. And let's start out by realizing that the actual First Amendment states that Congress shall make no law abridging the freedom of speech. That sounds like an absolute prohibition against any type of law made by the U.S. Congress that would abridge or basically limit our right to free speech. And like most things in the U.S. Constitution, although the language of the Constitution seems relatively simple, the actual meaning behind the words as interpreted by the Supreme Court is a lot more complicated. And in fact, it's in the state of constant adaptation or change, not constant, but the interpretation of that specific language in a variety of contexts can change, has changed through the years, and will continue to change in the future. Before we start to get into the First Amendment specifically, what I want you to think about are some critical thinking questions that you should keep in mind when we're going over when you listen to the lecture and when you read the material in Chapter 2, and especially the cases related to Chapter 2, which are in the second part of your textbook. Here are critical thinking questions. There are four of them. Well, first, why do the police need to know a lot about the First Amendment, especially the right to freedom of speech? Secondly, how does the Supreme Court interpret the First Amendment when they have to distinguish between speech and the conduct that is often demonstrated by the conduct that the speaker actually is engaging in? And three, should our speech, should it be protected in different ways based upon the content of the speech, or should we just have one general type of protection? And lastly, can government regulate speech? Can they regulate speech even if the actual reasons for the regulations are not based on the message? Let me rephrase that. Can government regulations, if they are based on considerations apart from what the speaker is conveying, the message, and they are regulating other factors, for example, the conduct, those regulations impinge upon the speaker's message, in some cases preventing him from portraying all aspects of the message, should that be the law? Is it the law currently? And are there good reasons for that? With these four questions in mind, we'll start with the basic idea of speech itself, and that's kind of a difficult question because somebody says, well, what exactly is speech? Speech involves any type of communicative behavior. That means it's not just you and I having this discussion. It also involves dancing. It could involve dancing. It certainly involves certain expressive conduct. It can involve me refusing to speak or being prevented from speaking. That can infringe upon my right. It can include my right to hold certain beliefs, to express those beliefs, and it often certainly includes against the idea of conduct that's symbolic in nature. It means my conduct is that I'm engaging in as an attempt to convey a message to the listeners or to the bystanders. So speech is a concept that's fairly all-encompassing in regard to human behavior. It's another reason why it's really hard to understand all the different parameters of speech regulation, the different judicial decisions involving speech, and why in some cases what seems like a fairly easy commandment, basically, Congress shall make no laws abridging the freedom of speech, in reality it can become almost like a legal minefield for people who are trying to go out and enforce order in our society when they are encountering a variety of activities that are actually one form or another of speech. Okay, we'll move on here and we'll look at two, basically, kind of frame this for you. When we talk about the First Amendment in regard to speech, the two overriding factors that you should keep in mind. One is that the content of speech itself, if it involves issues that are of public concern or involve the speaker's feelings about issues that involve society, the world in general, more of a if that's what the speech content involves, that speech will generally have absolute protection under the First Amendment. The second factor, though, to keep in mind is that the conduct that often accompanies speech, that can be regulated. In some cases, the conduct itself is speech, and that's a unique problem which we're going to talk about today. Protection of your right to free speech. Basically, as interpreted by the Supreme Court, we have three levels of protection in regard to our right of free speech. That's how the Supreme Court interprets it. For example, let me give you a scenario that when we start talking about speech rights, put yourself in the place of you, the citizen, and you're out, you're upset about a particular issue, and you go to participate in a rally. And while you're there, you're speaking about that issue, and you're advocating your position. You're on public property. The group has received a permit. They're protesting at the right time, and you're advocating an issue that involves basically an issue of public concern. At that particular time, your right is under free speech rights. You have you do have total protection at that time. And where we run into an issue is where there's something missing in that scenario. For example, there is no permit, and yet there are permit laws that you are not speaking about an issue of public concern. In fact, you may be insulting someone in the crowd, or you may be threatening somebody. You may be inciting the crowd. So these are areas in which you may end up violating a particular law or ordinance. And then the agents of the government, remember, again, like all the amendments, we're talking about protection from government actions. They're protecting us from government action. The police are the agents of the government. Let's say, for example, in this case, you're using offensive language to someone in the crowd. And there's an ordinance that basically restricts that type of language. Police come along, they tell you to desist, you say no, you get arrested, you are put in handcuffs, you're taken away. You may decide at that point that your language was actually within the protective environment of the First Amendment, and that the arrest was illegal, unjust, because in fact it violated your First Amendment rights. That is how these cases arise, through these factual circumstances where a law has been violated or an ordinance. The police, generally, who are the enforcers of this particular ordinance, arrest you and charge you, and you become convicted for violating a particular law or ordinance, and you challenge it on the basis of either the law or the actions or both being unconstitutional in nature and violating your First Amendment right to free speech. 3 levels of protection, though. Basically, free speech about matters of public concern in public locations, absolute protection. There's other areas of speech that receive no protection. And there's a 3rd level that receives limited protection. We'll deal with the 3rd one right now because it's one I'm not going to discuss. But the 3rd level, we're talking about speech that really involves commercial activity, or vulgar speech, vulgarity, speech is laced with profanity, or commercial speech, speech that is advocating certain positions on the public airwaves, that are trying to sell you things, that basically, they're really a profit-making factor to it. Something outside of just trying to advocate a position politically, and But anyway, let me move out from those areas itself. Commercial speech is an area that we don't have time to discuss in this particular video, and it's really not in your text either. All right, but the area that is important is what type of speech receives no protection whatsoever. And basically, we have 5 basic areas. And number 1, obscenity is not protected. Child pornography is not protected. Fighting words are not protected. Threats are not protected. And incitement to commit acts of imminent violence is not protected also. Those 5 categories do not receive any protection under the First Amendment. Which means that you can be arrested, charged for using speech, but unprotected speech. And you can't claim, and you as a citizen cannot claim that your rights have been violated if you're arrested for that type of speech. Again, remember the highest type of protection is when the content involves matters of public interest. And when the speech itself takes place in what is considered a public forum, an area that traditionally has been used for citizens to express their thoughts and feelings about matters of public interest, or in which an area that the government has specifically set aside for this type of public expounding of viewpoints. London in England also has an example of this. They have an area in Hyde Park called Speaker's Corner. And on Sundays, they have a certain hour set aside, and he said anybody can come up to Speaker's Corner, get a soapbox up, microphone, and speak about anything they want, and they can say anything they want. Great Britain has more restrictions on speech rights than we do. They don't have an amendment like our First Amendment because they don't have a Bill of Rights. They have kind of a living constitution. But on that particular day, during those hours, anybody can say anything they want to. They can disparage anybody. They can say anything. It's wide open in Speaker's Corner. We don't have that in the United States, but our rights to speak in general, I think, have greater protection than they do in Great Britain. All right, let me give you one example that I think you'll be interested in is if you've heard of the Westboro Church, the Westboro Baptist Church, it's been in the news recently. There's a Supreme Court case that I'm going to want you to look at on this, but their rights have been upheld in regard to their speech because basically they speak, at least the Supreme Court's main opinion, decided that their speech basically involved matters of public importance or public import or public concern, and that it was in a public forum, and they had met all the regulations. It's an interesting case, but you'll see that their behavior was pretty scandalous, disgusting in many ways. But the Supreme Court, in their decision by Justice Roberts, who wrote the opinion, decided that their behavior fell within the purview of the protections of the First Amendment in regard to free speech. Okay, non-protected speech. To go over non-protected speech in the time we've got available, I want you to realize that this normally involves public forums. And the public forums are where we go to speak. And this is the area in which the government has imposed, and traditionally has always imposed some types of regulations upon these forums, because one of the purposes of the government, one of the purposes in the preamble to the Constitution as to why the Constitution was written, it was to ensure domestic tranquility, to keep the peace. And that is a function of government. And the framers of the Constitution certainly understood that one of the areas in which speech rights would impinge upon domestic tranquility would be in these public forums, the streets, the public halls, the parks. And realizing this, we know that this is where the government is often going to come into contact with citizens who in some cases will engage in speech that will definitely destroy that tranquility. And through judicial opinions by the Supreme Court, they have eliminated speech protections for this type of behavior. As a good example of this case for you to look at, you'll notice in some of the cases you're reading in your textbook, they'll reference the Chaplinsky case. This is Chaplinsky versus New Hampshire. And the Chaplinsky case basically involved a state law, and I'll quote the law itself. It said that New Hampshire state law, this is in 1942, the use of any offensive, derisive, or annoying word to any other person who is lawfully in the street was prohibited. And with the Chaplinsky case, Mr. Chaplinsky was a Jehovah's Witness, and he was selling some of his magazines, where the police approached him because he was also making comments to the crowd, upsetting them, talking about organized religion and racketeering. Well, the crowd became upset. One individual tried to assault Mr. Chaplinsky. Other people were threatening him. The police came up. A police officer came up, tried to disperse the crowd, arrested Mr. Chaplinsky, and at that point, the police actually told him when they arrested him to get him away, said, the words were, "Shut up, you damn bastard." Mr. Chaplinsky then responded, "You're a damn fascist and a goddamn racketeer." Now, when those words were spoken, it was on the basis of those words that the state charged Mr. Chaplinsky with violating the statute. And he was convicted. He appealed to the Supreme Court on free speech grounds. His argument basically was that the fact that the speech is likely to cause violence is no grounds to suppress the speech. That, in fact, like Mr. Chaplinsky had said, he asked the police, "Why don't you arrest the bystanders? Why are you arresting me?" Well, the state argument was that this statute was a valid exercise of police powers, and that the police were just basically exercising that, and that their behavior was correct, and it did not violate the First Amendment. He went to the U.S. Supreme Court. They affirmed the New Hampshire Supreme Court, which had upheld the state. And it said that the U.S. Supreme Court said that basically the statute, as construed by New Hampshire Supreme Court, did not contravene the First Amendment protections for free speech. because the words themselves were likely to cause a breach of the peace. Well, Mr. Chaplinsky is a good example of, the Chaplinsky case is a good example of when certain language can reach the point in which it falls outside the boundaries of free speech. Now today, the Chaplinsky case is still cited as controlling precedent. It is mainly because the statute was fairly carefully drawn and was specific as to the type of language that it would restrict. Another area involving another case that you're going to see cited quite a bit for speech rights involves the area of symbolic speech, where conduct itself is intended to convey a message. And you'll notice in some of the cases in your textbook, you'll hear about the O'Brien case or the Brine Test. And this was the U.S. versus O'Brien case that took place in 1968, and it was involving a protest against the Vietnam War. And some anti-war activists, including Mr. O'Brien, they burned a draft card on the steps of the South Boston courthouse. Now, there was a selective service statute passed by the U.S. Congress that basically made it a crime to destroy or mutilate a draft card. Well, Mr. O'Brien was arrested for burning his draft card, and when he went to trial, the lower federal courts actually said that his behavior was expressive conduct and it was protected by the First Amendment. This eventually went to the Supreme Court, and the Supreme Court held that actually it was symbolic contact. If it was symbolic in this particular case, the conduct involved with it, then the statute was restricted to the conduct, not the content of or the expressive nature of the conduct. It was after the actual conduct, and because of that, Mr. O'Brien's case, he was found guilty of. Actually, the case was reversed. To be retried, he was found guilty of violating the selective service laws. The Brine Test is basically a test used to regulate conduct when speech is involved with conduct. And it basically means that if the law that is being applied to the symbolic expression, if the law itself serves a substantial government interest, in this case, for example, in the O'Brien case, to regulate the getting us ready for war, getting soldiers into the draft. If that's the reason for it, a substantial interest, and it was not involved with trying to regulate the speaker's message, then that will not violate someone's free speech rights under the O'Brien Test. In your textbook, you can look at your Texas versus Johnson case, which is another form of symbolic speech action involving flags, involving burning of a flag, where you're going to see kind of basically a similar rationale being used. But in this case, the O'Brien Test was not implicated in the Texas versus Johnson case, which was in 1989. And they found that in this case, the particular law that was involved was actually part of the state interest was in controlling the type of message that was being conveyed by the symbolic conduct, the burning of the flag. And that took it out of trying to apply the O'Brien Test. And in this case, the fact that conduct was involved, but it was actually also trying to influence the message. It was involved with basically suppressing the type of message that Mr. Johnson in this case was trying to convey, his dislike of the U.S. government. That because that was the reason for the statute, or at least was one of the reasons for the statute, then the First Amendment protections that that Mr. Johnson claimed were actually, he was right in that particular case. That statute was trying to infringe upon his First Amendment right of expression, in this case a form of symbolic expression, the burning of a flag. It was obviously an unpopular decision. At the time, many states had passed similar statutes protecting the flag. The U.S. government subsequently actually passed an act trying, again, against burning the flag. Supreme Court took another case, again found that the congressional act against burning the U.S. flag was also unconstitutional. They talked about having an amendment to the U.S. Constitution, and that never happened. So the current state of the law is still that if you're burning a U.S. flag, if it's your flag, you're in a public location or your own private house, and this is to convey a message that it's your flag. Basically, you have the right to do so, and it falls within the First Amendment protections. I think that if you look at these two basic ideas, the fighting word exception, the symbolic expression of the fighting words exception, basically the protections that we have involving political speech in public areas, that it basically shows that the forum where it actually takes place is sometimes another area in which we'll have to look at what types of regulations the government can impose. Now, the forum area is generally public forums. Protections are obviously extremely strong. For the state to pass regulations in a public forum, they've got to have a compelling interest to restrict the regulations that might impinge upon your speech rights. They have to have a compelling government interest. If the forum is a public forum, but it's used by the government for the routine activities of the government, that gives it a lesser degree of protection in regard to your speech rights, because at that point, as long as the government is passing reasonable regulations, and those regulations do not single out any speaker, that they are restricting activities because there's business going on by the government entity that is passing these regulations, then generally those regulations are going to be upheld as long as they do meet this reasonable test and as long as they're content neutral. There's an area also involving private areas. Private areas, of course, since they're not under governmental control, do not fall under the Constitution, the Constitution's protections under the First Amendment. Some states, however, are able to pass laws basically telling private owners of property what type of behavior they have to allow. But again, this is not a constitutional issue. Hopefully that answers some of the questions that you may have about the First Amendment protections towards your right to free speech. Thank you, and we'll see you on the next video.